I realize that I'm standing between you and a pint of Guinness and a glass of wine. How does this work? Okay. I'm going to take you to the dark side in a few minutes. Let me say that no, it's okay. That's working fine. Yep. It's okay? Yeah.
I actually don't think it'll move.
Oh.
If I just... Yeah, if you just go here.
Why does anyone use Microsoft?
There you go.
So my interest is in regime change, in sociology, the politics, the ethics, and the law of regime change. I put together a course last year in India on comparative totalitarian law, which I get quite excited about, I have to frankly admit. And it's fascinating that somebody described regime changes as a symbiosis of violence, terror, and law, and how difficult it is to disentangle all of these three things. There was a French aristocrat traveling through England 300-400 years ago, not de Tocqueville, somebody else, who said that lawyers are like weeds that grow in gardens cultivated by the hands of others. And once they take root, they extinguish all other living vegetation. What he was getting at is the infinite manipulability of legal forms, the susceptibility of law to undo itself, and the amoral character of most lawyers. Most, I say, not us here today. And the lack of an obvious anchorage point to try and hold back against violent ruptures, and so on and so forth. And law plays a role in legitimation as well as delegitimation. And what's really fascinating to me is how systems, not just the laws, but the systems themselves can undo themselves. And people who violently disagree with the orientation of a system can quite easily enter it, assume a leadership role within it, steadily deconstruct it, and then convert it into its mirror opposite. In a way, that's what De Valera did, and certainly that's what Adolf Hitler did in the 1930s, at almost exactly the same point in time. Now, I know you're going to say it transmogrified into two completely different outcomes. Fine. But the point is there are intrinsic dangers to this tactic of legality, and I don't think we've answers to them to this day. You see, for example, what's happening in Hungary at the moment, and indeed in Poland and in other places. And one of the troubling, deeply troubling things about the deconstruction of the Weimar Constitution, whom everybody has mentioned here very positively, is how it was dismantled legally and democratically. And I would suggest to you, flashing forward, the European Convention of Human Rights is not actually about human rights. It's about protecting particular rights in order to lay down concrete anchors to an integral liberal democratic order. So obviously, I'm not going to spend too much time on De Valera's tactic of legality. You all know it. You all know the badges of inferiority, or the perceived badges of inferiority, that De Valera and many, many others in the country felt about the 1922 Constitution. You all know that these badges of inferiority irked, and that De Valera had to swallow hard to enter into the system, to take his oath of loyalty, fidelity, whatever, and then how he used the legal form of the amending provision of the Constitution and others, not just his party, to basically extend a technical provision that was intended to enable the new executive and the parliament to deal with flaws that might become obvious in the first 8 years of the system. He used it to extend itself, that enabled him, therefore, to begin purging many of these badges of inferiority, which included the right of appeal to the Privy Council, the oath of loyalty itself, etc., and then combining this with the Statute of Westminster to do the next logical thing, which was to breach with the 1922 Constitution altogether. Mind you, the treaty, which was the anchorage point to all of this, was never formally abrogated until, I believe, 1998, as part of the all-encompassing peace process with Northern Ireland and the UK. So there are some out there, some lonely wolves, who say that the adoption of the 1937 Constitution was itself unconstitutional. I'm not going to go down that road, but I want to point to how that very same tactic of legality led to something completely obnoxious and different to what we're used to. I'm going to flash forward here because This is based on something I did last year. I think it's really interesting. Carl Schmitt's idea of deep state, you didn't need it, because in the original Constitution, the 1870 Constitution, on its face, in the preamble, says the authority for the Constitution is most definitely not the people. It is not popular sovereignty. It's the will of the princes or the kings or the principalities in the German Empire as it was evolving at that time. And by the way, the Wilhelm I, not his stupid son who caused the First World War by giving a blank check to Austria-Hungary, pardon? Grandson, was crowned Kaiser of the Germans, not the German Kaiser. There was a difference in Versailles, which is why the victors held their conference in Versailles in 1918. So really, really interesting. And the theory was the state comes before the Constitution. And that's just a very easy step to Carl Schmitt's view that the deep state is the most important thing. And that, of course, Hitler exploits by developing the Völkisch theory of the state, a deep sense of community, not a million miles away from Catholic theories and Gaelic theories of the future of the Irish state and so forth. So you had very, very interesting provisions, which I'll glance over because time is of the essence. But note the Chancellor, the Chief of Government, is appointed by the Kaiser, not by the Parliament. The Parliament has no say. And indeed, the Parliament was rigged in Germany. The Parliament was rigged in the sense that the aristocracy, who might be 3% of the population, always had 30% of the seats. The workers, who might be 80% of the population, could only command 30% of the seats. So in as much as you view a political system as something that facilitates change, this is exactly the opposite. So, of course, it was handled very smartly by Bismarck by making prudential concessions left, right, and center. But once he was out of the picture, the system was bound to collapse at some point in time. The interesting thing about the 1870 Constitution is there was a provision on emergencies in there which became the precedent for Article 48 in the Weimar Constitution in 1919. Okay, let me move on from that. Okay, because I don't want to. So this is the 1870 Constitution, no set of articles on the judiciary and no section of articles on fundamental rights of the citizens. So, okay, Carl Schmitt didn't work in a vacuum. He was really basing himself on the old authoritarian constitution of the 1870s. By the way, the judiciary was really conceived of as the civil service. And you had a long period of apprenticeship, maybe 15, 20, 25 years, in order to be able to weed out independent-minded judges, and that's exactly what happened. And one of the big mistakes in the Weimar period is they didn't purge the judiciary of these people who were more state-minded than the actual state itself. The architect-in-chief of the 1870 Constitution, here you go, Bismarck, the doyen of realpolitik. But of course, it's unsafe to rely on people like this because once they're out of the picture, the flaws in the system inevitably tend toward destruction. So we had the Kaiser essentially dominating the cabinet, appointing it, not accountable to the Parliament. We had the Parliament rigged by this tripartite system whereby people who are demanding change never could have their voice heard. The judiciary had no constitutional status, and the Kaiser controlled the national army, and the army swore an oath of loyalty to the Kaiser. And there's grandson. Sorry, I got it wrong, not son. Actually, he was Queen Victoria's nephew, wasn't he? Very, very stupidly gave the Austrians blank check. So let me see if I can move on. I'm not going to deal with that. You've heard Reichstadt already. You know all of this about the outbreak of the First World War. By the way, enabling acts were a standard provision in German law. And one of the most infamous was not so much the Nazi one, but the one enacted in 1915, whereby the Kaiser and the Parliament gave power over to Ludendorff and Hindenburg to actually control civilian affairs, and they basically sidelined both the Parliament as well as the Kaiser himself. What happened at the end of the First World War, as everybody knows, is there was a revolution. It's called a revolution from above, meaning the Liberal Democrats, the bourgeois, the people who wanted to have a parliamentary system just like the British and envied the British, decided it was time to make prudential change. Very quickly that collapsed within 2 months, and there was a revolution from below, whereby the SPD and the Social Democrats, commensurate with their real size in the population, actually grabbed power for themselves. The interesting thing is, this is unconstitutional. Everybody saw it as unconstitutional. There was nothing in the 1870 Constitution to make space for this. But some legal historian, very famous legal historian, is that everybody acknowledged, even those on the hard right as well as those on the hard left, the law-giving power of the November Revolution. Interesting thing is, if these political change circumstances legitimate a new entity coming into being, why can't the Nazis use the same set of logic in 1933 to justify the legal order that they're bringing into power? The Weimar Constitution suspended the 1871 Constitution, never abrogated it, and the Versailles Peace Treaty was acknowledged at Versailles, which irked many, many people. Let me move on, because what I really want to get at is the actual, just an interesting point about the reparations. The Germans imposed massive reparations on the French after the Franco-Prussian War in 1870. The French paid every cent, and it was proportionately higher than the reparations imposed on the Germans in 1918, 1919. And by the way, if the Germans actually finally paid their reparations, it wouldn't have been until 1988 when they actually paid off their final reparations. Somebody said, between the French Foreign Chancellery and the British Foreign Commonwealth Office, if we are going to hit them with such deep reparations, we have to have a theory of legal liability. This is where it's dangerous to hand things over to lawyers. And the British Foreign and Commonwealth Office invented the notion of German war guilt in order to be able to justify the theory of extended reparations being imposed. I'm sorry why I digressed, but I thought you'd find that interesting. So what basically happened is the Weimar Constitution, that's President Ebert, the guy who basically stepped into the breach as SPD Chancellor. This is the father of the Weimar Constitution, Hugo Preuss. Now, it wasn't just De Valera who hated lawyers. Hitler absolutely abominated lawyers, partly because one of the few top professions Jews were allowed to enter was the legal profession, and of course they excelled, and partly because they were carriers of a bourgeois tradition, a limited state, albeit not really applied very rigidly during the Bismarck period. Hugo Preuss himself was not keen on rights. He wasn't very careful in how he crafted the rights in the Constitution. He converted the president of the new Weimar political entity as an Ersatz-Kaiser, deadly dangerous, as we'll see. Didn't transform the legal system, so the old system of appointing judges and keeping judges in place was retained, and had absolutely no theory of judicial review, unlike De Valera and others in 1937. I'm going to flash beyond that because I'm really trying to get at the tactic of legality. Okay, so what happened then was the Weimar Constitution innovated with a series of rights. And they're mainly bourgeois liberal democratic rights. You might have thought that an SPD-dominated assembly would have put in social rights. They didn't. And I think one of the reasons they didn't is because they were called upon to suppress the Spartacists, Rosa Luxemburg and others, and they were afraid of being perceived, particularly by dominant elements in their society, as being too revolutionary. In any event, there was rather loose language in the Constitution, whereby some of these rights didn't really appear inviolable, and that if positive law to the contrary were enacted, then by definition they had made inroads into the substance of these particular rights. Okay. There was interesting transitional arrangements. The Constitution of the German Reich of 1871 was suspended, wasn't purged, interestingly. And in fact, the Weimar Constitution called itself a constitution for the Reich. They couldn't actually put distance between a new democratic order and the theory of the Reich, which left a window for Volkisch theories as well as deep state theory to come back in. The slogan of those who were against this constitutional order was Heute rot, morgen tot. Today you might be red, as in SPD, but you might be dead tomorrow. So the theory was very simple. It had inverted the 1870 Constitution. The people were now sovereign. There were some rights, but there was no clarity on who was to actually enforce these rights. And instead of a Kaiser, there was a president, but that president looked very much like a shadow Kaiser in terms of the extent of his or her powers. We all know the stresses that it came under, and we all know this guy, right, who learned his lessons. A little bit like De Valera. I don't want to make that into too much of it. You don't confront the system head on. You don't engage in outright violence. You might at some point in time use it prudentially, but what you can really do is enter the system, deconstruct it, take it over and convert it into its mirror opposite. So that's exactly what his theory was. And he did develop this notion of the Volkisch theory, not just of the community, but of law and of the state. And so Carl Schmitt really was playing to a ready-made audience. Let me quickly move up beyond that. So Hitler came into power in 1833. He had to share power with others. Didn't like that one little bit. And he had to exercise power within the terms of the Constitution. And just like De Valera, he'd been thinking, how the hell am I going to actually deconstruct this? How am I, in De Valera's instance, going to deconstruct it by abusing the amending power of the Constitution? And in Hitler's context, how am I going to use the tactic of legality to destroy and gut the internal workings of the Constitution? So Hindenburg was very old. He was very susceptible to his son, who was a bit of a twit. And he decided to invoke Article 48 of the Constitution. Article 48 of the Weimar Constitution is based on a similar provision in the 1871 Constitution. It did imagine that at some stage there would be a law regulating the use of this exceptional provision. That law was never enacted, okay? And if you were a literalist-minded judge, you would say, yes, you can do this, yes, you can do that, but there's no law regulating, so therefore invalid, okay? So there were plenty of opportunities to actually declare that invalid. By the way, the text had no definition of an emergency. It had no requirement of proportionality. It had no sunset clause, so it could exist into the future. And the interesting thing is, we'll see later on that the Enabling Act, which I'll describe momentarily, was extended every 4 years punctiliously at the dot, right up to the end of the Second World War. The actual text of Article 48 says nothing about the inherent right of the executive to issue decrees in place of legislation voted by Parliament. But such was the deep theory of state that the Germans had. They actually interpreted Article 48 to allow for rule by decree, even though there's absolutely nothing in Article 48 that warrants that. So we all know about what precipitated the use of Article 48. Here it is. And the really interesting thing about reading the Reichsgazette, right, is you'd think, oh my God, am I going to have to read 40 pages of legislation? By the way, the Americans now have legislation reading parties, which are a bit odd. But all of this legislation is like 2 paragraphs long. Beautiful for law students because they have, the mind space for that. First of all, it said, articles blah, 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 which are all the basic civil rights in the Constitution, are invalidated, not just suspended, invalidated. It gave a list of punishments in lieu of regular punishments, which could include the death penalty, and it comes into immediate effect. Interestingly, co-signed by Hitler and Hindenburg as president, although legally speaking, that's not necessary. Okay, we all know what happened in terms of the timeline. Hitler forces Hindenburg to issue the declaration. He's returned to power, obviously, and he uses the space created by the use of Article 48 to begin the process of deconstruction. So a lot of laws were enacted right throughout 1933, right to up 35, gutting the Weimar Constitution. I'll move on for a second. Oh, there's a picture. Sorry, why can't I get these Microsoft products to work? There's a picture of Albert Einstein fleeing Germany in 1933, right after Hitler begins this process of deconstructing the Constitution. He also had a knack, almost a demagogue's knack, of ratifying retrospectively a lot of these moves through plebiscites, but of course by then narrowing the constituency of eligible voters so that he's pretty much guaranteed the outcome. I want to just touch on this because it's relevant to some of the debates we've been having about Carl Schmitt and others. There was a huge debate within legal theory in Germany, but also within constitutional law, about what was called methods and direction of law. And the dominant thinker was Paul Leband, which interestingly, he was a positivist, not a natural law person. Natural law comes into this equation after the Second World War as an aspect of Anglo-American victor's justice, not in the actual debates in Germany in the 1920s and the 1930s. His basic idea was that we go for text rules. And if text rules and the Constitution says that the president can do this but can't do that, then there are definite limitations on what the president can do. So Article 48 cannot be used in the way that Hindenburg did. So interestingly, it's the positivists who support the idea of maintaining the integrity of the liberal democratic order. And people forget that. There was this big debate in the 1920s, several German constitutional law conferences. Some were championing Paul Leband, the positivistic people, on how we must take the text seriously. If the text said in 1871 that the princes are sovereign, and if they now say the people are sovereign, that must have implications for the metes and bounds that we draw around executive power and so forth. And the anti-positivists, including Carl Schmitt and many, many others, held no, the deep state hasn't gone away, you know, that even though we've switched to notions of popular sovereignty, it's just fluff on paper, and therefore the deep state is what actually counts. I'm not going to go through this. I can subsequently write it down for you. So he's used the Article 48 to silence critics, to outlaw parties, except the Nazi Party. And then, in order to further concentrate power, he enacts, or the German Parliament enacts, the Enabling Act. Okay. Now, this is really interesting in terms of the Act of Union in Ireland and so forth. Did the German Parliament have the inherent jurisdiction to surrender their jurisdiction to the Chancellor and ultimately to the President? Note what the Enabling Act, and this is the German Parliament, so to speak, voting freely, although that's open to doubt because several of the SPD people, certainly the communists, were arrested before they went to Parliament. I always say to law students, you don't get this freedom about freedom from arrest and going to and from Parliament. Look at this. Look at this. This is what really brings it alive to you. So in a sense, the majority was rigged, but it was still a majority. And even if it weren't rigged, he probably would have had a majority over time, right? Look at it. It's very simple. Law students should love this. It's just one paragraph. Laws of the Reich can be passed not only in the manner prescribed by the Constitution, but also by the government of the Reich, okay? And basically, eventually, that means the whole Constitution is subject to amendment by the Reich, meaning Hitler personally, okay? Laws passed by the government of the Reich can be at variance with the Constitution. The institutions of the Reichstag and Reichsrat are untouched. Nonsense. They were abolished. The Reichsrat was abolished, the Senate, so to speak. The Reichstag was kept in place, but it was not convened. It was prorogued indefinitely. And in fact, Hitler hardly ever held any cabinet meetings. All decisions were made very close to himself. So it was used, the Enabling Act was used to destroy many of the remaining political space in Germany. Here's my Americanism. Why not do a combo, okay? If you've got Article 48 to suppress civil rights, and you have utter, complete legislative power because of the Enabling Act, then why not arrogate to yourself the powers of the president? And that's exactly what happened in August 1934, whereby the office, this is very great for law students, right? It's just 2 paragraphs, very simple. The office of the president is combined with that of the Chancellor of the Reich. And this was done before Hindenburg had died. He was on his deathbed, and 2 days before he actually passed away, this was actually enacted. So what you end up with, here's the army swearing an oath of allegiance personally to Hitler. There was nothing in the Weimar Constitution to say this. They were supposed to swear their oath of loyalty to the chancellor, to the president in his office, but in fact they didn't do that. They swore it personally to Hitler, which is why some of the Wehrmacht had some difficulties in actually resisting the Einsatzgruppen and the SS as they followed them into Poland and elsewhere. So finishing off, here is how the judiciary was finally neutralized. Even if the judiciary couldn't be counted on to do as they were told, and largely they did, they created a special criminal court, nothing like our special criminal court, very much more like the Star Chamber in England of medieval times, with Roland Freisler here as the Chief Justice, who mercifully was bombed out of existence by the RAF toward the end of the war. You can go on YouTube and see him in action in many of his cases. It's the most anti-judge-like figure you could actually imagine. And that was a handy way of just dispatching antisocial elements. And one of the interesting things about criminal law in Nazi Germany is we have a tradition that you can't be prosecuted or convicted simply for an act. There must be an association with the act, with your mental intention, and so forth. They turned that on its head and said, instead of crimes of behavior, we're now going to have crimes of condition. So just because you're Jewish, or just because you're blind, or just because you're Polish, you are now liable to be extinguished. So we had the worst of all worlds, sweeping Article 48 powers with the Enabling Act, and then used to actually create the Völkisch state, the Gaelic state in Germany, and a vacuum of power, no public-private distinction. And I was saying to somebody earlier on, it was the Irish and the Belgians who insisted that there would be a right on the family and privacy in the European Convention of Human Rights, obviously for Catholic social teaching. They were pushed back hard by the other negotiating parties who said, what's that got to do with maintaining the integrity of a liberal democratic system? They scratched their heads, they went back to the negotiating table, and they said, actually, that's one of the first things the Nazis destroyed, the sense of integrity of the family unit group, which is one of the last insurance policies you have against authoritarianism. And that's how that ended up in the European Convention of Human Rights. So the tactic of legality in Germany was spectacularly successful. And I would say it was spectacularly successful because the judges did not take seriously the literal wording of the Weimar Constitution. They are much more inclined to the Völkisch deep theory of state and so forth. And obviously the 1948 Constitution, and specifically the European Convention of Human Rights, is a response to that. The tactic of legality worked extremely well in Ireland as well, because we created arguably an unconstitutional constitution, but nevertheless a very successful constitution. What's the difference? I would say the difference has to do with our British heritage, in the sense that there always was a residue of respect for the liberal democratic order, parliamentary sovereignty, and so on and so forth. And so you get essentially a liberal democratic constitution in 1937 with Irish characteristics, to be sure, but the spine of it is still recognizable as a liberal democratic constitution. The thing about Germany is, in the Weimar period, somebody famously said, we have a republic, but no Republicans. Nobody is committed to the idea of parliamentary democracy or liberal democracy, which was one of the reasons why it was so easy for the tactic of legality to go so spectacularly wrong in Germany. Thank you very much.